On December 20th, 1860, in the aftermath of Abraham Lincoln's election to the presidency, South Carolina declared its secession from the Union. In the following months, 10 other southern states followed suit, and together they formed the Confederate States of America to protect slavery from the increasingly anti-slavery North. To provide a legal basis for secession, the southern states adopted a radically expansive view of states' rights known as compact theory. However, while the Civil War was the most extreme use of this theory, it was far from the only one. Compact theory has roots going all the way back to the earliest years under the Constitution, and it has shaped conflicts between the federal government and the states all the way up until the present day. Compact theory originated in the 1790s as a response to Congress's passage of a set of laws known as the Alien and Sedition Acts. These laws were highly controversial because they effectively criminalized criticizing the government and were used to prosecute the government's political opponents, a pretty blatant violation of the First Amendment. Thomas Jefferson and James Madison were especially outraged by this, so the two of them anonymously wrote the Kentucky and Virginia resolutions, which argued that states could and should oppose these laws. The two of them interpreted the Constitution as an agreement, or a compact, which all the states had agreed upon. The federal government was created by this compact, meaning each state had the right to decide the constitutionality of the federal government's actions. Madison believed this meant states could declare federal laws unconstitutional and take steps to protest them, like getting other states to make similar declarations or advocating repealing the law. This is called interposition. Jefferson took a more extreme view, arguing that if a state declares a federal law unconstitutional, then it can completely invalidate that law within the state and forbid its enforcement. This power is known as nullification. Jefferson and Madison's resolutions created compact theory, an interpretation of the Constitution which empowers states with the right to declare federal laws unconstitutional. They hoped that the states would adopt these resolutions to declare the Alien and Sedition Acts unconstitutional, but only Kentucky and Virginia ever did, while 10 other states passed resolutions repudiating their ideas. Nonetheless, opposition to the acts helped carry Jefferson to the presidency in the election of 1800, and the act which outlawed criticizing the government expired right at the beginning of his term. As such, the Kentucky and Virginia resolutions were effectively rendered moot, though the ideas expressed in them persisted. A little over 30 years later, compact theory reemerged at the center of a crisis over Congress's imposition of a highly protective tariff. South Carolina despised the tariff, objecting to its constitutionality by claiming that Congress exceeded its authority in passing a high tariff which protected domestic industries rather than a small tariff which just provided revenue. According to them, all taxes had to apply equally across all the states, but the tariff's protectiveness disproportionately benefited the more industrial northern states while harming the more agricultural southern states. Opposition to the tariff in South Carolina grew so strong that in 1832, the state invoked compact theory to formally nullify the law. South Carolina further declared that if the federal government attempted to use force against it to enforce the law, it would secede from the Union. These antics outraged President Andrew Jackson, who, although a supporter of states' rights, firmly opposed nullification and secession. Jackson proclaimed that nullification flew in the face of both the spirit and the letter of the Constitution. He specifically pointed to the Constitution's Supremacy Clause, which makes federal law superior to state law, meaning that if the two ever conflict, federal law wins. He also argued that if every state could nullify every law that it didn't like, then the entire constitutional system would fall apart. In Jackson's view, the Constitution was not a compact between multiple sovereign states, but a compact between the people of one nation. As such, secession was illegal because it destroyed the unity of that nation, making it nothing short of treason. At Jackson's urging, Congress passed the Force Bill, which authorized him to use force to uphold the law. At the same time, Congress passed a lower tariff, which was more acceptable to South Carolina. With the passage of these two laws, South Carolina finally backed down, rescinding its nullification ordinance and ending the crisis. However, both sides were able to declare victory. South Carolina successfully used compact theory to pressure Congress into making concessions, while the federal government successfully reasserted its authority by pressuring South Carolina to comply with the law. Although the nullification crisis was over, compact theory had not been defeated. Nullification was taken up again over a century later as part of a showdown between Arkansas and the federal government over desegregation. In 1954, the Supreme Court declared segregation in public schools unconstitutional because it violated the Equal Protection Clause, and a year later it ordered public schools to integrate with all deliberate speed. This decision was reviled in Arkansas, which amended its state constitution to declare the ruling unconstitutional and to order the state government to oppose the ruling in every way possible, effectively nullifying the court's decision. Nonetheless, the Little Rock School Board began implementing a plan to integrate schools in Little Rock. However, when 9 African-American children were about to attend Central High School in Little Rock, the governor of Arkansas, Orville Faubus, sent the state's National Guard to the school to prevent them from attending. In response, President Dwight Eisenhower deployed federal troops to Central High to ensure that the school was integrated. Still, the state government's firm opposition to desegregation and threats of mob violence against black students made integration difficult, causing the Little Rock School Board to seek court approval to delay integration, and eventually, this case, Cooper v. Aaron, reached the Supreme Court. In a unanimous landmark decision, the court denied the school board's request for a delay, rejecting Arkansas's attempted nullification in the process. The court recognized that the school board was acting in good faith. They were actually trying to integrate Little Rock schools, and they had legitimate concerns about how to implement integration because of the state government's actions. However, the court ruled that good faith alone was not a good enough reason to deny students their constitutional rights, especially since the only reason they were requesting a delay was because of the state government's unconstitutional actions. The Supremacy Clause makes the Constitution the supreme law of the land, and the Supreme Court is the final authority on the meaning of the Constitution. Because the Supreme Court found that the Constitution demanded integration, Arkansas had to integrate its public schools to be compliant with the Constitution. Integration was now part of the supreme law of the land, and Arkansas's attempt to nullify it was plainly unconstitutional. With this ruling, the court explicitly rejected the doctrine of nullification, asserting the supremacy of the Constitution and the federal government. However, compact theory doesn't just posit that states have a right to nullify federal laws. Taken to its extreme, it also posits that states have a right to secede from the Union. The logic goes that because the Constitution is a compact between the states, each state has to fulfill certain obligations outlined in the compact. If a state determines that the other states are failing to uphold their end of the deal, the compact is broken, and that state can now secede. Following Abraham Lincoln's victory in the 1860 election, Southern states feared slavery was under threat, so they invoked compact theory to claim they had a legal right to secede. Specifically, they claimed that the northern states had broken the compact by failing to abide by the Fugitive Slave Clause, which says that if a slave escapes into another state, that slave must be returned to their master. Congress passed the Fugitive Slave Act of 1850 to more strictly enforce the Fugitive Slave Clause, but it sparked widespread outrage in the northern states, so they passed personal liberty laws that impeded enforcement of the act. These laws were then attacked by Southerners, who claimed that they violated the Fugitive Slave Clause. As such, in the South's eyes, the North was no longer fulfilling its obligations under the Constitution, thus breaking the compact, meaning the South was entitled to secede. With the anti-slavery Republican Party now in control of the federal government, the South believed secession was the only way to protect the existence of slavery, and using compact theory, they claimed that secession was legal. Abraham Lincoln, on the other hand, did not think secession was legal. Assuming that compact theory was correct, Lincoln argued that the northern states had not violated the Fugitive Slave Clause because the Constitution was ambiguous about who was supposed to enforce it. According to him, the responsibility of enforcement belonged to the federal government, so if some state governments chose not to enforce it, they were fully in their right to do so. In other words, the compact was not broken. Additionally, even if the compact had been broken, Lincoln claimed that unilateral secession would still be illegal because a compact can only be dissolved by the mutual consent of all the involved parties. A state can't just decide to secede from the Union unless the other states allow it to. Otherwise, secession was nothing more than insurrection, and it was the federal government's duty to suppress insurrections. All of this assumes that compact theory is the right way to interpret the Constitution, but Lincoln disputed this too. In his view, the states did not create the Union by agreeing to the Constitution. Rather, the Union predated the Constitution, going all the way back to before the American Revolution. This Union was made perpetual by the Articles of Confederation, and was made more perfect by the Constitution. If the Constitution was preceded by a perpetual Union, then how could it possibly be more perfect if it was no longer perpetual? Compact theory cannot be correct because the Constitution did not create the Union between the states, it strengthened one that already existed. After the Union's victory in the Civil War, the Supreme Court heard the case Texas v. White, where it considered the legality of secession. The case revolved around bonds the Texan government had sold during the war to finance the state's rebellion against the Union. With the war now over, the state's reconstructed government sued to reclaim the bonds, arguing that the rebel government had been illegitimate, meaning the sale was invalid. The court agreed with this argument, deciding that secession was illegal, thus making any actions the state government took to support its secession null and void. In its ruling, the court adopted a similar view towards secession as the one Lincoln had expressed. The Union was not created by a compact. Rather, it grew out of the history, beliefs, interests, and geography the states all had in common. It was confirmed during the American Revolution, declared perpetual by the Articles of Confederation, and perfected by the Constitution. Although the Constitution recognized that states have some autonomy, it also enshrined the indestructible union between them. Once Texas joined this union, it didn't just agree to the terms of a compact, it became a fully integrated part of an indissoluble nation. As such, when Texas tried to dissolve this union, it did so illegally, and since the bonds were sold to finance the state's illegal rebellion, their sale was invalid and they had to be returned. With this ruling, the court definitively declared unilateral secession to be illegal, dealing a decisive blow to compact theory. That didn't mean compact theory went away though. In recent years, it's made a bit of a comeback. Back in 2021, Texas passed a law which effectively banned abortions after 6 weeks of pregnancy. At the time, abortion was a constitutional right because of the Supreme Court's decision in Roe v. Wade, so Texas's law seemed to violate this. However, the law was unique in that it could only be enforced by private citizens suing people who help provide someone with an abortion, making it much harder to challenge the law's constitutionality in court. Basically, when a state passes a potentially unconstitutional law, you can sue to get the law struck down before it can be enforced. While you generally cannot sue the state itself, you can sue the state officials who'd be responsible for enforcing the law, but since Texas's law could only be enforced by private citizens, there were no state officials to sue, meaning courts couldn't strike it down. To encourage private citizens to enforce the law, the state financially rewarded people who brought suits using it, essentially creating a bounty hunter system that indirectly banned abortions, as abortion providers were now unable to operate for fear of being sued. When abortion providers tried to sue state officials to get the law struck down, the Supreme Court ruled against them because the state officials weren't involved in enforcing it, thus giving the law and its unique enforcement mechanism a green light. With this ruling, the court basically allowed Texas to invalidate the Constitution's protection of the right to an abortion. Although the court overturned Roe v. Wade a year later, deciding that the Constitution didn't protect a right to an abortion, the success of Texas's law showed that states could use this bounty hunter loophole as a form of nullification free from judicial scrutiny. Not long after Texas passed its abortion law, California passed a gun control law modeled after it. California's law banned manufacturing and distributing assault weapons and ghost guns, and it banned giving firearms to anyone under 21, provisions which potentially violate the Supreme Court's rulings regarding the Second Amendment. Like Texas's law, it could only be enforced by private citizens suing people who broke it, and the state would financially reward people who brought such lawsuits. Essentially, California's law ignores the Second Amendment, and even if its provisions are unconstitutional, its enforcement mechanism protects it from being struck down. Notably, several people who supported the passage of this law believed it was unconstitutional, but they hoped the law and its bounty system would be struck down to discourage other states from passing similar laws. Regardless, Missouri passed its own gun law which made use of a bounty hunter system, the Second Amendment Preservation Act. The SAPA explicitly declares several federal gun control laws to be unconstitutional violations of the Second Amendment and declares them null and void in Missouri. Any local or state agency which tries to enforce one of those laws in Missouri could be sued by a private citizen, who would then be rewarded by the state government. Missouri's law, unlike Texas or California's, goes much further because it expressly identifies and purports to invalidate multiple federal laws, making it a much more blatant attempt at nullification. However, this fact has also made it much harder for the SAPA to stand up to judicial scrutiny. In a federal appeals court, the SAPA got struck down on the grounds that it claimed to nullify federal law, thus violating the Constitution's Supremacy Clause. Missouri effectively tried to revive the same kind of nullification used by South Carolina in the 1830s, just with a new coat of paint, even directly invoking compact theory as legal justification for the state's nullification of federal law. Over 2 centuries after its inception, compact theory is still being used as a weapon in legal battles between the states and the federal government. Whatever your opinion on abortion or gun control, laws like the ones passed in Texas, California, and Missouri are clearly wrong. If states can just nullify any federal law or constitutional right they disagree with, then what's the point of even having them? Nullification obviously violates the Constitution, basically rendering the whole thing meaningless, and it makes the United States a whole lot less united. Of course, states do have autonomy over certain things, and it's definitely good that they do, but that doesn't mean they can just ignore the Constitution when it's convenient. The federal government is inevitably going to do things that some of the states disagree with, but nullification is not a solution. Compact theory should always be rejected every time it pops up in the fight over states' rights.